The Firm, India's only show on corporate law, tax and audit matters.
Hello and welcome to The Firm. This special edition is coming to you from the capital city as we mark a landmark day in which the Supreme Court struck down the National Judicial Appointments Commission as unconstitutional. The court said that the selection of judges to the senior or higher judiciary will continue to be done by the collegium system. Now, the collegium is a 5-member body, the Chief Justice of India and 4 senior-most judges of the Supreme Court. It was set up by the Supreme Court itself in the 90s in response to what went on with the judiciary in the emergency years. Last year, though, the government amended the constitution to change the process of selection of judges and move it to the NJAC, which is a 6-member body. Only 3 positions go to the judiciary. That's the Supreme Court Chief Justice of India and 2 senior-most judges of the court. The 4th position goes to the Law Minister and the 5th and 6th position to eminent citizens selected by another panel. While the collegium has attracted quite a bit of criticism over the last few years for being opaque, arbitrary, lacking objective selection criteria, the NJAC, many said, was not the answer, and hence it was challenged in the Supreme Court today. Well, the NJAC lost and the collegium won, but the government seems to suggest that the Supreme Court, in doing so, has ignored the will of the people. Here's Attorney General Mukul Rohatgi.
The collegium system has now has been directed to be revised by the court. The collegium system is not a system which is found in the constitution. According to me, the system is not appropriate, and again, at least in the future now also, appointments will continue to be made in an opaque system where all the stakeholders will not have their voice.
The government may not be very happy with what went on in the Supreme Court today, but my next guest, Arvind Datar, definitely is. Mr. Datar was amongst those eminent jurists who argued against the NJAC and in favor of the collegium. I asked him if this victory was sweeter than any other victory he's ever had. Mr. Datar, congratulations to you. It is an important victory, more important than most other victories that you've had in your career today.
Oh yes, I mean, if the case had gone the other way, it would have had a long-term effect on the appointment process and perhaps on the entire independence of the judiciary. This is perhaps the most important case of the day of the 20th century, perhaps 21st century. What is your reading of how the Supreme Court bench of 5 judges arrived at this decision? It was a split decision. 4 of them voted against the NJAC. Yes, Justice Chelameshwar dissented. How do you read the grounds on which they found the NJAC to be unconstitutional? Well, the 3 main grounds which they spelled out in open court were that there is no need to consider the 2nd and 3rd judges' case. Now, these 2 cases laid down the collegium system, and the Union of India had made a very, very strong demand that was argued for at least a week that those 2 judgments had to be reconsidered, and they wanted to refer it to a 11-judge bench to reconsider whether the role of judges in the appointment process is part of the basic structure or not. That has been turned down. So now the 2nd and 3rd judges' case have become final. They can't be questioned anymore. Then they came to the constitutional amendment, and 4 out of 5 have said in no uncertain terms that the Constitutional Amendment Act is unconstitutional and violative of basic structure. They made that very clear. The next process is the Judicial Appointments Commission Act, the parliamentary law. That also has been held to be unconstitutional by 4 out of the 5 judges. On the last act portion, Justice Chelameshwar, who took a different view on the constitutional amendment, he said that since everybody has decided to strike down the act, I need not spend time on that. So that's how the judgment went. What is it that they found unconstitutional about the NJAC? Was it the fact that the Supreme Court or the judiciary no longer had the primacy in appointing judges to the higher judiciary? Was it that some aspects of the selection process were left to a law which can be easily amended by the Parliament, or to regulations even and not spelled out very clearly in the Constitutional Amendment Act? Yes, right from the beginning it was clear that the Constitutional Amendment was very badly drafted, and so was the Act. It's seriously flawed. And the ground on which they struck down the Constitutional Amendment was primarily this concept of eminent persons, which had not been defined. And also one of the judges said that the participation of the Law Minister would influence the appointment process in an impermissible way. Then they also went into the individual articles and pointed out that certain provisions are totally unconstitutional because they undermine the judiciary. In simple terms, what they said was, as long as you give primacy to the judges in the appointment process, right from the initiation of the selection up till the appointment process, it is valid. But this amendment gives executive a much larger role, and therefore it's impermissible. They also dispelled the doubt. They said the public are under a common misconception that under the collegium system, the judges are what Dr. Ambedkar called imperium and imperio. That is, they are all supreme. He said that is not the case. Even in the collegium system, the matters are referred to the government. The government's opinion is taken into account, and that's a fact.
Yes.
It's not that they just go off on their own. So they said that it is a consultative participative process. And they said that the collegium system has given a structure. It's not just the Chief Justice alone who decides or the Minister alone who decides. There are 3 or 5 judges. They call for the objections, and the whole thing is a participative process, and that is valid. To the extent that the constitutional amendment doesn't make it very clear, because they said you got a veto power, then you not only undermine the Chief Justice's role, you undermine the judge's role, and Justice Lokur pointed out that you also undermine the President's role.
Okay.
Because even after the President is interested, you can simply veto it. And there were no reasons on which you can veto. These 2 eminent persons can be just say that we don't like so-and-so and veto it. And we also argued that this could lead to structured bargaining, you see. And it could seriously vitiate the appointment process. As far as the Act is concerned, they went into individual sections. Like there was a very strange provision which said that the entire appointment process of the NJAC had to be tabled before Parliament, and Parliament could modify it. So this was, they said, obviously absurd, because if NJAC is an autonomous body, where is the question of Parliament then sitting in judgment over it? So that was bad. Having said that, one other thing which I thought that the judgment doesn't seem to, the judgment is 1030 pages.
Yes, it is.
So unless we read the fine print and find out what are the common threads among the 4 judges,
which is going to take a few days at least,
yes, I
in
think
terms of
make
determination.
A complete chart and see who says what. The main thing which we had also argued is that we said that to make it constitutional, please put the entire appointment process in the Constitution itself. Don't put it in a parliamentary act. They recorded the submission, but I didn't see that it has been dealt with in a very elaborate manner.
But could that be that having struck down the NJAC as violative of the Constitution, they didn't need to get into the process then of how the NJAC functions at this point? Because that really is, what comes next after having sort of decided on a body that works.
I think you're right, because I got the impression that having struck down the basic, that it is, you're destroying the primacy of the judiciary, they perhaps thought it's not necessary to go into the other questions.
One of the other things you brought up, Mr. Dattar, when we were talking before the interview was, when it comes to the constitution of the NJAC, which is 3 judges of the Supreme Court, the Chief Justice plus the next 2 senior most judges, the law minister and 2 eminent persons. Eminent persons you've already spoken of, but you said one of the judges also brought up an objection against the presence of the law minister on a panel of this nature.
Actually, Mr. Jetmanani, who was also on the council, he seriously objected to the law minister's presence. He said he was himself a law minister, and he said that he knows, or he knew, what an important role a law minister can play and how his presence could vitiate the appointment process. That seems to have been accepted by one of the judges, Justice Lokur, who has said that the presence of the law minister could influence the appointment process, keeping in mind his presence in the cabinet and the role he plays in the appointment, in the entire process. Okay,
Mr. Jetmalani today on Twitter has said all the government law officers should resign, given that they've lost the case.
No,
I know, I'm just saying that tongue in cheek. But so is it fair for us to then surmise that almost every aspect of the NJAC has found to be violative of the Constitution by 4 judges of the 5-judge bench, and unless this is rewritten by the Parliament in a substantive fashion, it is not going to find muster with the Supreme Court?
Yes. I think if Parliament wants to redraft a new constitutional amendment to introduce the NJAC in the presence of the collegium, then they'll have to make sure that in the selection committee or the selection process, judges have primacy. That is, the majority can't be otherwise than with the judges. You can have participation by an eminent person or by a representative of the government or a speaker or some 2 members of whatever they may be, but the majority must be with the judges. And in fact, we made a comparison of 192 constitutions before the Supreme Court, and we said that even where there are judicial appointments commission, where there are lay people also, the common people also, in many cases the last word is left with the judges.
But there are many countries, sir, where the judicial appointments are political.
Oh, yes.
Whether it's the US and the appointments to the Supreme Court are done by the President and then sort of ratified by the Senate, or several other countries where the political class is keenly involved in the appointment of judges. And that brings me to my next question. How do you see this progressing from here on? Is this the final round in the battle between the judiciary and the parliament or the political class? Do you expect that the government may attempt to move forward on this, either by asking for a review or by rewriting the Act and still seeking to, sort of replace the collegium? Is this going to sort of, is this battle going to continue?
Well, first answering your question, if you compare the 192 constitutions, we took 192 because there are 192 members of the United Nations.
Sure.
So we took their constitutions. The pattern followed by India, where the judges have a primacy, are there only in 4 or 5 countries in the world.
So we are in a minority.
Where there is no Judicial Appointments Commission. There are about 50 odd countries with the Judicial Appointment Commission. There are countries where the king or the president straight away appoints. So there is a complete mix. There are many countries where there is appointed by commission, but it has to be ratified by parliament. So there are multiple processes. We need not worry about that. We can have our own process. Now, what's the way forward? Now, 2 options are there as far as I see. One is that the Supreme Court has now posted the case on the 3rd of November, and asked all the parties concerned to give concrete suggestions to improve the collegium process, so they can issue directions. Maybe they want to have a operating procedure where from the selection process, from the finding out who are the potential candidates to the appointment, there is some kind of a set procedure which is transparent, fair. That could be the intention. Well, the government can either participate in that and do it, or as far as the judgment is concerned, nothing prevents the government of the day to have a fresh amendment, bring in a new NJAC law, which gives the judges the primacy or the supremacy.
But given how quickly the NJAC, the Constitutional Amendment and the Act were passed, given that it found support across political, the political class, given that the Act or the bills were born under the UPA and passed under the NDA, and there seems to be one rare moment of unanimity within our politicians when it comes to this, do you think the government's going to give up without a fight?
Yes, I think it's rare. It's really it's a rare unanimity. I mean, they have been unanimous only twice. One when they increased their own salaries, and the second is when this judicial appointment came. And I was quite surprised, because such an important bill, such a badly drafted bill, despite the fact that many members of parliament are lawyers, nobody even saw that how potentially fatal this amendment could be. It was just over in a day. In fact, I am told that except Mr. Jetmalani, nobody is opposed either in the Lok Sabha or the Rajya Sabha. All members unanimously, without bothering about the consequences. And we also told the Supreme Court that when such a important change comes, where you're going to alter the entire appointment process and it's going to be for the next 25-30 years, it could at least refer it to the select committee, referred it to the bar associations, called for their comments. Nothing was done. Okay,
one final question then, Mr. Datar, and that is that the critics of the collegium system, and there are many, and in fact I think you yourself have in previous interviews pointed out that there are many flaws existing in the collegium system, are very disappointed today. So if you look at social media, if you look at some of the commentary on media, some people have termed it as a loss for transparency and a victory for opacity. What do you think the Supreme Court needs to do on an urgent basis to fix its own house?
One criticism which is common, which I've heard again and again, is that we do not know on what basis you choose and select X person or Y person to be a potential.
So more transparent, objective criteria.
Standard criteria, more objective selection process. And perhaps the pool from which you select judges, how do you take it into account?
Well, that's Arvind Datar making the case for a modified collegium, but not quite the NJAC. Right after this break, we'll speak with another eminent jurist here in the city of Delhi, a constitutional heavyweight, Harish Salve, and ask him what he makes of this decision. Mr. Salve was in favor of doing away with the collegium system.
The Firm, India's only show on corporate law, tax and audit matters.
Welcome back. You're watching a special edition of The Firm. Today we're marking a landmark decision by the Supreme Court against the NJAC and in favor of the collegium system. Earlier this evening, I spoke with Harish Salve, a very well-known face in Delhi, and a man who had argued against the collegium system and in favor of the NJAC when he represented the state of Haryana in this series of PILs. Well, I asked Mr. Salve whether he was disappointed with the outcome today.
Mr. Salve, thank you for your time. Thank you for speaking to CNBC TV 18. You know, in all our conversations in the previous years, you've said two things. That the primacy of the judiciary is not necessarily in question, though there is a debate on how the Constitution looks at that, but that judges should not appoint judges. Are you disappointed with the outcome of this big battle in the Supreme Court today?
I have mixed feelings, let me tell you honestly. Yes, I am disappointed that the Supreme Court has gone to the extent of saying primacy of judges is part of basic structure, as it were. I have not carefully analyzed the judgment, it's a 1,000+ page judgment, but what I have read, there was quite a distance the court had to travel to get to grapple with the real issues. And I'm very happy the way it travelled that distance and the conclusion it has come to.
Okay.
The government invited the court to go back to a literal interpretation of the Constitution, which we left behind.
Second judge's case and the third.
No, we left it behind in the 60s, where we started, where we had creative judges like Subbarao, Shah, who created a great constitutional jurisprudence which the world looks at with envy. Today, to argue that when your Article 21 says right to life means life, made by law by Parliament. If Parliament says if you steal a pen you will be put to death, that will be valid. That kind of an argument. We are seeing it again. No right to privacy.
Father, yeah.
So these kind of arguments are what the court had to deal with initially. Literal interpretation. Look at the Constitution Assembly debates. Of course, the framers of the Constitution never thought of judicial primacy because they never expected the executive to behave the way it did
in the
80s and 90s.
Yeah.
So, constitutional law has to evolve, and constitutions which don't evolve and which become rigid then lead to revolutions. So, evolution of the Constitution is very good. At the time in 91, when the Supreme Court was confronted with the problem of executive excesses and that imperiling judicial independence, within the language of the Constitution they came up with a construct in which they said judicial primacy. Correct? That was a solution for that problem. But that doesn't mean there cannot be any other form, any other structure, any other institution which can serve the same purpose.
But you're saying many things in the same answer, sir. You're saying that and this is my understanding of what you're saying, is that maybe the government argued it to one extreme, in suggesting that we should go back to a literal interpretation of the Constitution. So maybe they got their strategy wrong. Secondly, is that what you're saying, that they got their...
It's not strategy. It's a question of how you approach the Constitution. So I'm very happy we traveled. When you asked me whether I was disappointed, I'm very happy that we traversed all that distance and we have put the Constitution in the correct perspective.
Okay.
The real issue which I feel I'm at odds with the judgment is judicial independence is not negotiable.
Fine, we all agree with that.
It's not negotiable.
Yeah.
We all have to discover the finest way of achieving that. Judicial primacy is one way of achieving judicial independence. It has its pitfalls. The court records rightly, with some degree of anguish, the kind of stuff they had to hear about the functioning of the collegium. There were some very unpleasant moments in court. I was not there, but I was told.
But you did argue, I think, for a brief period on behalf of the state of Haryana. Yes.
The point is, the Supreme Court is an institution which should never be in a situation where it has to hear stuff like this. So there are problems in judges taking on the role of appointing more judges, because then the accountability for bad judges comes on to the court.
Right. But this is the argument you've made as well, Mr. Salve, that the collegium has failed us time and again. The collegium is not the perfect answer. So why are you saying that the Supreme Court ought not to have heard...
You just said two things. I agree with the second.
It's not the right answer.
It's not the right answer. It is not the only answer.
Well, it's not the only answer, but the NJAC sounds like a very, very poor alternative.
See, NJAC may be a poor alternative because of point number 1, 2, 3, 4, 5. We can address all those issues. The real issue is something else. Let's get the matter back in perspective. You have an amendment to the Constitution which says there will be an NJAC. Now, one objection which I understand the logic of is the structure of the NJAC is no longer not a part of the Constitution.
Many of it is part of the Act and
it's
delegated.
The Act. Should this be in the Constitution? I can understand that argument saying you're delegating from the Constitution into a statute. Today you have a structure with 2 eminent people, 3 judges. But if you leave it to Parliament, what is there to say Parliament can't tinker with it? Answer is, if they come up with a law which doesn't pass muster, you can challenge it, etc. So there may be an argument to say, please put it back in the please put all this in the Constitution. That's one. There are certain concerns about how the independent people will be selected, what is the independence, how it is to be done. You need to flesh it out a little more. Maybe. The government needs to have a comprehensive action plan and on that basis make the amendments. Maybe that was a valid criticism. Whether that is good enough to strike down the law, or the court should have told the government, please go back to the drawing board and come back to us and tell us how you're going to work it.
But this court is not stopping the government from doing that, right?
No, they struck down the amendment to the Constitution.
Yeah.
They're back to the collegium system.
So, yeah, I agree.
If there were flaws in the system, we could have ironed them out. The Supreme Court's judgment ultimately then goes to the point that wherever there is absence of judicial primacy, it violates basic structure. That is something which, as a constitutional lawyer, I find difficult to accept.
Okay, so I have 2 quick questions to ask you. How do you expect, or how do you suggest the government should proceed from here on? And secondly, maybe the good outcome of all of this that's gone on over the last few years is that finally the Supreme Court is, in a sense, admitting that yes, there are flaws in the collegium system and we're willing to hear views to rectify those flaws and come up with an improved system. So we may end up with a better system which may not be the collegium, which may not be the NJAC.
Well, let me take your second point first. Yes, there has been significant and trenchant at times criticism of the way the collegium has worked. And well, if it has to be there, I'm happy the court is willing to look at tweaking it to improve it. What the government should do, I'm too small a person to advise the government. They have wiser heads and they will, I'm sure, come together and decide what should be done. One of the, purely as a lawyer and person fond of constitutional jurisprudence, one option to the government could be, this is not my suggestion, this is my view, they can go back to a drawing board and see dispassionately if there are any things which are in the judgment of the Supreme Court which commend themselves, saying maybe we are wiser after seeing this, we should tighten this or tighten that, and come up with an amended constitutional amendment.
Okay. Final question then. Who won today? Did the judiciary win? Did the government lose? Did India win? Did the Constitution win? It's so difficult. This is a complex issue. And I think the responses have been so varied in terms of, oh, but the people wanted this. Why did the Supreme Court not pay heed to it? Oh, but why is the Supreme Court being so rigid? Oh, thank God the Supreme Court did not give in to political requirements and protected its independence. Who won today?
Let me tell you, fixing the process of appointment of judges is something which you need to do, whether you go back to the improved collegium or whether you go back to a judicial appointments committee. Nobody wins, nobody loses. We all gain when the system improves. But I'll tell you who won today. The Constitution of India won because the judges looked at everything but the fact of how many MPs voted in its favor.
Okay.
The day Indian Supreme Court judges started looking at which way the political winds blow, that will be the end of our Constitution.
And that is the perfect note to end this show on. It wasn't the Supreme Court or the judiciary that won today, or the government that lost today. It was the Constitution that won. That was Harish Salve. On that note, I'm going to wrap it up here on The Firm. Thanks very much for watching this special edition. We'll see you again next week.
The Firm, India's only show on corporate law, tax and audit matters.